Hello, hello, hello. Hey, everyone. So I have some rulings from Judge Boreski here that we're going to read together. Judge Boreski has ruled on Lori's some of them were pretty bewildering motions, and he definitely, in my opinion, throws some shade at Lori. Before we get there, though, there is a case out of Utah. Last night, Alisa Petrov was found safe. She turned herself in, and I know that this is not a case that we were covering in depth, but we were watching it here in depth for Hidden True Crime, ready to report on it, preparing to go to discuss it this week. Very concerned about this 15-year-old girl. And so here's the breaking news. This is from Heidi Hatch last night. And it says, breaking incredible news. 15-year-old Alisa Petrov is alive and well. She turned herself into the Colorado Springs, Colorado Police Department this evening. So somehow in Colorado. I just spoke to South Jordan Police, who are working with Petrov's parents to reunite them. South Jordan Police say she is safe, well, and in good health. It is too early to say if she was at any point held against her will, how she got to Colorado. We expect more information as it's gathered in the next couple of hours. Watch KUTV 2 News starting at 4:30 a.m. for updates. So again, that was last night. Just wanted to let you know that because I felt an absolute relief. I've been so worried, and I thought many of you might be too, for those of you that have been following that case. All right. Thank goodness, right? I love a good ending. I was so worried about her. All right, so Lori's filings, guys. Lori's filings, and I'm here at the Maricopa County Courthouse. I'm first in line for media. I knew that with jury selection, because we're going to do voir dire this morning, allegedly, we hope, unless something changes. And I know that there's very little room in there for the public and media both to be there. So I got here really early. I'm first in line in the media line, and let's hope it goes well. So. And then as I'm sitting there upstairs, what happens is trying to write a backstory for another case we're covering, preparing. Oh, the docket fills up. Boom, 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 boom. Minute rulings come down. Boom, boom, boom. So let's start with number 1. So to remind everyone, this is the minute entry. The court has received and reviewed the following. Motion to suppress all evidence pertaining to the Jeep Wrangler license plate LWD 0997 dated May 7th. So again, Lori Daybell has requested that the Jeep Wrangler be suppressed as evidence because there was the Jeep wasn't saved, nor was the window, the shattered window, which again, people have implied, well, how do you save a shattered window? You know, a bullet hit the window, it's shattered all over. So, all right. So I was reading the wrong one. I wanted to go over this one. So what I'm talking about is the Jeep Wrangler. It's the motion to dismiss for non-preservation of crucial evidence. So again, that's the window, the shattered window, and the Jeep. Motion to dismiss this entire case because the police did not preserve crucial evidence, filed May 17th. That's better. I was like, I'm on the wrong one here. So here we go. Short and sweet from Judge Boreski's ruling. The defendant fails to establish with any specificity what additional relevant evidence could have been discovered had the actual car door and window been preserved by the police, nor does the defendant assert what additional testing, measurement, or analysis could have been done had those items been preserved. Finally, the defendant also fails to assert how additional analysis would or could lead to exculpatory evidence. It is ordered denying the motion to dismiss for non-preservation of crucial evidence dated May 7th, 2025. Short and sweet. So in other words, Lori Daybell has failed to show what relevant evidence could have actually been discovered had the car door and window been preserved. Yep. Denied. And she wanted to throw out the entire case because of that. Next one. Let's do that one I brought up. So this is all evidence pertaining to the Jeep Wrangler license plate. This was because, again, believed that a search warrant had been properly given to seize the Jeep Wrangler in Idaho, the Jeep Wrangler where the rifle was pointing out of, police say, to shoot Brandon Boudreaux, that came from Idaho and showed back up in Idaho before and after the shooting, and the Jeep Wrangler that was registered to Charles Vallow that allegedly Tylee Ryan used to drive. All right. So here is the ruling from Judge Boreski on that. The defendant's motion alleges the Jeep was seized in Idaho without a warrant, which is apparently not correct. The defendant's reply states she received late disclosure, which revealed the Jeep was in fact seized pursuant to a warrant. The Jeep was held in police impound until the second search warrant was issued, at which time a search of the Jeep was conducted. Whether the state did disclose the information late is a separate issue to be dealt with separately, but late disclosure does not impact the substance of whether the issued warrants were valid or invalid. The defendant asserts without any evidence the Jeep was unlawfully seized. The defendant attached no copy of the search warrants in question. So, really quickly, he does admit that, like, whether the state disclosed this information late is a separate issue to be dealt with separately, meaning she can deal with that issue, because that is an issue. If she didn't receive that from the state and the information's late, take that up. But this is not that issue. The defendant asserts without any evidence the Jeep was unlawfully seized. The defendant has no copy of search warrants in question. If a warrant has been issued, there is a presumption that the warrant is valid. The requisite probable cause having been shown, see United States versus Ventresca, and the state versus Superior Court, it is then the individual's burden to prove the invalidity of the search and seizure. State v. Warren. A defendant has a limited right under the Fourth Amendment of the United States Constitution to change the validity of a search warrant by controverting the factual allegations made in the affidavit in support of the warrant, citing Franks v. Delaware. A defendant must show that a misstatement or omission in the affidavit was deliberate or reckless on the affiant's part, and that the misstatement or omission was material to the finding of probable cause. Where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included in this warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held in the defendant's request. This is People v. Lee, citing Franks v. Delaware. As has been explained to this defendant, okay, this is good. You ready, guys? This is good. This is where I think he's, kind of being throwing some shade. As has been explained to this defendant previously, just making a statement that something is unlawful is not evidence, nor does a conclusory, guys, it is so early, statement create a substantial preliminary showing that any statement in the affidavit was material false. So, just making a statement that something is unlawful is not evidence, as this has been explained to the defendant previously. Here, the state does acknowledge that the wrong year number for the Jeep was listed, but that would hardly impact the determination of probable cause to issue a warrant. The defendant has presented nothing more than hyperbole alleging the warrant is invalid. She could have attached the warrants in question and pointed to specific statements therein to support her assertion, but failed to do so. The defendant has presented no evidence which warrants a Franks hearing. It is ordered denying the defendant's motion to suppress all evidence pertaining to Jeep Wrangler license plate, date May 7th, 2025. In a previous response, by the way, we have heard that Detective Ray Hermosillo is who received the search warrant for the Jeep, filed the search warrant for the Jeep, and realized that the search warrant had a little mistake in it, waited to seize the Jeep, got a new search warrant for the Jeep, made sure everything was accurate as far as information on the Jeep, and then seized the Jeep. So not only was there a search warrant for the Jeep, it was done very methodically by Detective Ray Hermosillo, and when it didn't come out just perfectly, he started over and received the appropriate search warrant. So we've heard that in a previous, minus the case law here, we have heard how it went down in Idaho, and that's how it went down. So, yeah, denied, Lori. Okay. Now let's go to defendant's motion to preclude evidence of phone data and text messages dated May 5th. So in other words, well, I'll just read this. The defendant, Lori, argues phone data and text messages relating to Alex Cox should be precluded for two reasons. The messages are hearsay and the information was illegally obtained. So honestly, I'll be honest, maybe I'm a little slow, but I did have questions about why maybe Alex Cox's messages weren't hearsay when Charles Vallow's body cam, was. They're both deceased. I'm talking about the last trial, like Charles Vallow sort of predicting his death on police body cam footage, saying my wife's trying to kill me, was considered hearsay. That bothers me. And I was wondering, like, why then wouldn't Alex Cox's messages be hearsay? And let me be honest, I don't necessarily think that Alex Cox's messages should be hearsay. I think I'm more so just still confused. I know that Charles Vallow's body cam footage was hearsay. And I know that everyone says, well, he's dead and he can't testify. I know that. But I just feel like it's so much a part of the case. Why? Questions have still remained. So this ruling from Judge Boreski is helpful to me. Here we go. So the defendant argues that phone data and text messages relating to Alex Cox should be precluded for two reasons. His messages are hearsay and the information was illegally obtained. Alex Cox's text messages are admissible pursuant to ARS Rules of Evidence 801-2E and are specifically defined as not hearsay if the statements are made by the party's co-conspirator during and in furtherance of the conspiracy. Okay, there you go. So even though Alex Cox is dead and he can't testify or be cross-examined about the context of his text messages, they are not defined as hearsay because they are made by the party's co-conspirator during and in furtherance of the conspiracy. Boom. I had a question answered. Thank you. Pursuant to ARS Rules of Evidence 801-2E. That is why. The defendant cites the Stored Communications Act, page 2 of motion, in support of her assertion that the phone information was unlawfully obtained. However, that same act that she cites, you guys, thank you so much. Same act that she cites in section 2703 states that contents of wire or electronic communication, electronic storage, etc., are only accessible by the government pursuant to a warrant. The defendant goes on to cite various requirements for pen register and trap and trace warrants, which are not applicable to this case because those are not the types of warrants issued in this case. Those warrants refer to ongoing monitoring of lines, commonly referred to as wiretaps. So she is referring to ongoing wiretapping, which isn't happening 6 years later. The defendant's reply admits the warrants were issued, but argues that they fail to acknowledge that the state court and law enforcement are obligated by federal and state laws to ensure the revised or amended statutes are followed. It is not the state's burden to establish any of those things. It is the defendant's burden to establish that the warrants were not lawfully obtained. So show us that they weren't lawfully obtained, Lori. And by citing the same act that they're proving you wrong with isn't helping. If a warrant has been issued, there is a presumption that the warrant is valid, the requisite probable cause having been shown. In other words, she has to prove that they weren't lawfully valid, and she's not doing that. It is then the individual's burden to prove the invalidity of the search and seizure. Quote, defendant has a limited right under the 4th Amendment of the United States Constitution to challenge the validity of a search warrant by controverting the factual allegations made in the affidavit in support of the warrant. Citing Franks v. Delaware, a defendant must show that a misstatement or omission in the affidavit was deliberate or reckless on the part, and that the misstatement or omission... I have my phone on Do Not Disturb, but guess who can bypass Do Not Disturb? My husband. So that was John calling. Just denied John too. Lori's getting denied by a judge, and I just denied a call by my husband because we're talking. I'll call him later. Okay. A defendant must show that the misstatement or omission of the affidavit was deliberate or reckless on the part of the misstatement or omission was material to finding a probable cause. The defendant did not attach the individual warrants nor the affidavits associated with any warrant. Finally, other than making a statement that the information collected from an iCloud account or other storage devices went beyond the permissible scope of the warrant, the defendant, though, has not submitted any evidence of that. Once again, she doesn't submit any evidence. She just states something. And as the judge has said, stating it doesn't make it so. You can't just say something and then not prove it with evidence. Where's the evidence? Lori seems to forget this thing called evidence. Evidence. It is ordered denying the defendant's motion to preclude evidence of phone data and text messages dated May 5th, 2025. All right, we've got one more. Which one haven't I read here? I've kind of gone back and forth. Okay, yeah, last one. So remember, okay, here's the last one. Remember Tammy Latchik. That was a witness that Lori brought concerns up. Remember, I was like, does she have a point? It felt worrisome to me, right? Like, it was last year, December of last year, so less than a year ago. Tammy Latchik was arrested. Was she arrested? Well, I shouldn't say that. Was it she detained? I can't remember. I read it all. It was a key witness, a concern. And she is the one that received all the DNA evidence. She was let go from Gilbert Police Department. That I know after this incident. She was found drunk in her hotel room in December of 2024. And her son had said she's had an issue with substance abuse for years and that they've been trying to get her help. So that's what we know about Tammy Latchik. Additionally, Tammy Latchik is who took the DNA from the Jeep. Or no, from the gun, right? You know what? Let me just read. This is the response. We've all been wanting to know, what are they going to say about this key witness? She seems like a very, very important witness in this case. Here we go. The court has received and reviewed the following. State's motion in limine to preclude inadmissible evidence relating to Tammy Latchik, filed May 3rd, 2025. State's motion to file motion in limine to preclude inadmissible evidence relating to Tammy Latchik under seal. So that was under seal. We learned that. Filed May 3rd, 2025. Defendant's objection. So this is a reply to her response. Defendant's objection to and request to unseal state's motion in limine to preclude inadmissible evidence relating to Tammy Latchik. Defendant's response to state's motion in limine to preclude inadmissible evidence. So this is a reply to Lori's response, objecting to, that. So the specific conduct occurred on December 30th, 2024, and that conduct does not imply the witness's character for truthfulness and the remoteness of that witness's conduct occurring on or around December 30th, 2024, 4 years after she completed work on this case, November 18th, 2019. So we're talking 5 years after the fact. This time from December 30th, 2024 to November 18th, 2019 is too great in time to make it relevant to her work in this case. While the specific conduct alleged would be relevant to impeach the witness's memory or ability to recall information on or about December 30th, 2024, it is too far removed on November 18th, 2019 to make the conduct relevant. It is ordered provisionally granting the state's motion in limine regarding this witness's specific conduct on or about December 30th, 2024, should the defendant think she has established through cross-examination some nexus between the conduct and the witness's work on this case. The defendant shall ask outside the presence of the jury to reconsider this ruling before asking questions regarding the witness's conduct on or around December 30th, 2024. Thank you, Zara. Tammy was not arrested. I know, right when I said that, I thought, hold up, I didn't think she was, so I want to emphasize that. She was let go from Gilbert Police Department. So thank you. Thank you. I want to make that clear. So, yeah, So, okay. Let's see. I'm looking now at things. Her son took her home. Thank you, Zara. I wanted to be very clear. Tammy Latchik is not Tammy's wife. Tammy Latchik is the person who gathered the DNA from the Jeep Wrangler. She was not arrested. Her son took her home. But she was let go from Gilbert Police Department. All right, guys, I'm gonna go head back in. Well, let me check out. I've got a bit. Let me check out chat. I'm gonna put all of these. By the way, all of these rulings and responses will be put on our Patreon account, patreon.com/hidden2crime. And to those that are on Patreon, forgive John and I for not. It's been a couple weeks since we've had our bonus Patreon episode. I know we do that every week for you guys, and we haven't done that. It's been so busy. And we were going to do that when I was home for 36 hours, but I just wanted to hang out with the fam. I'll be honest. So we will have a bonus episode soon. John's going to talk about things, and we'll have all these rulings on there too, just for those that are on Patreon. All right, let me see. Thank you, Marta. It's a thank you, Kay. Hello, Ladder Daily Digest. Carrie Lee, Sarah Hunter. Yes, Jennifer Ann Hunter. Some news on Lori too. For those that are new to my channel, this is because I see some people don't know where they are right now. Lauren Matthias, Hidden True Crime. We cover what is hidden, and in ongoing criminal cases, and unpack it with my husband, Dr. John Matthias, clinical and forensic psychologist, criminal psychologist, also known as. So anyway, I'm going to go in. Is Lori here? We don't know. Look, if Lori ends up being sick again, I'll be going live again. Everything seems good. Everything's running smoothly this morning. So what's going on? There are 2 lines. One for media, one for public, which actually hasn't happened yet because everybody's kind of been invited into jury selection, which makes me think they really are upping their game today. They're probably going to do opening statements this afternoon, heading into jury selection, or voir dire, like the important part of jury selection where Lori questions the jurors. Like, that's a big moment. So it's going to be a really big day. As I said on Friday before heading in after lunch, this is going to be a big afternoon because Lori is going to question the potential jurors, and no cameras allowed in the courtroom during that time. So I was going to be the eyes and ears. And what happened? Lori allegedly got sick, we think, most likely. Will she be better today? I don't know. Everything's running smoothly so far, and court's supposed to start at 10. Nobody's said anything, and the media contact for the courthouse is walking around, and everything seems good to go. And then after that, it'll be another big moment because according to their plans, they've got to get this show on the road. And so they're going to just jump into opening statements as well. So hopefully Lori's feeling better. Jury, jury, jury. We need a jury. Yeah. You're welcome, Tamara. You're welcome. Justice for Brandon. Chris Ann, thank you so much. Thank you, thank you, thank you. So also, guys, we're going to live stream the trial here. I hope everybody understands that we're live streaming the trial here. Thank you for those that give your hidden memberships. We do have a lot of fun with members only emojis. There's no way to actually give our emojis out without a membership. Like, YouTube doesn't make that possible. And we love our trial emojis. So thank you for those that gift memberships. It's so fun to be here. Troublemaker Baker, I see you here. So we do plan to live stream. So this afternoon, if all goes as scheduled, which is what our plan, opening statements right after lunch, we will be live streaming that right here, and we'll have a link to that live stream. Hey Troublemaker, so good to see you. 30-minute delay, yes, but we will start it on time, like when court starts, just so you guys know, but we'll have like a standby screen, like standby, this is going on. And a big thank you to Troublemaker, who's been very creative in all of the emoji making. I just want to give her a shout out. We love you, Troublemaker. You're a DJ, you're an emoji maker. You know this case like the back of your hand. We appreciate you. So, and all of our moderators. Thank you to all of our moderators. So anyway, live stream will most likely start this afternoon if all goes as planned, and I'll let everybody know from the courthouse, or I'll let troublemaker, you know, and if all goes as planned, we'll have that live stream scheduled and set up, ready to go for opening statements so we don't miss a beat. And then, of course, I'll be the eyes and the ears in the courtroom for everything jury selection. We've got you covered. And, of course, as always, we go live tonight. Hello from Sweden. Hi from North Carolina. I love it. Okay. All right. May justice be served for Brandon Boudreaux. I know that we are done with Lori. Lori, are you done yet? We hope you are. But we are not done with justice. So let's, I'll be here and make sure Brandon Boudreaux gets the justice he deserves. We'll see you. Hello, Switzerland. And Israel. Shalom from Israel. South Africa. Oh my gosh. All right. Johannesburg, Canada, Indiana. All right. We'll see you guys. Bye-bye.